It is a great honor for me to introduce our first speaker of the day, someone that I know when I go to the AAJ conventions and seminars, when his name is there, I'm going to be in the room. And that, of course, is Howard Nations. Howard specializes in pharmaceutical litigation, catastrophic injury, and wrongful death cases. He's board certified by the Texas Board of Legal Specialization as both a personal injury attorney and a civil trial attorney. But we all know him because he is nationally recognized for his trial work. He is the former chair of AAJ's NCA. He's a trustee of the American Jury Foundation and past president of the Bell-Eye Society. And the Bell-Eye Society, if you haven't participated in that, you really should think about it. I spoke at their presentation at the last AAJ seminar, and it's a terrific day. He also serves on AAJ's executive committee as vice president. He has been vice president, secretary, and treasurer. He's a diplomat of AAJ's NCA, and he has spoken in all 50 states and internationally. I can either go on and on and on and tell you all of the tremendous accomplishments of Howard Nations, or I could just ask him to please come up and speak to you himself. Thank you very much.
Good morning. One of the most significant things that's happened in my career has been my connection with Dave Winter and my connection with Lisa Blue, two of your speakers here today. I've always been fascinated with how the human mind works, the decision-making process. And when I was in the process of studying this, I ran across Dave, found his work to be fascinating, and Dave and I started giving speeches together. And we do a one-day seminar on psychological principles and applying psychological principles to trials, and we've spent a lot of time along with other people trying to figure out just how does all this forensic psychology work into the trial of a lawsuit. Dave called me some time ago and said, "What's up? What are you doing?" And I said, "Well, right now, I'm in trial in a legal malpractice case as a lawyer, not the defendant. I'm preparing a mass tort case in Judge Weinstein's court in Brooklyn, and I'm preparing a catastrophic injury case, brain injury, wrongful death case in Arkansas. Aside from that, pretty much free." We talked about the fact that those three cases, as different as you could possibly be, I was defending a legal malpractice case for a friend of mine. I was bringing a mass tort case on behalf of 950 plaintiffs, and we were getting ready to try the bellwether cases in Brooklyn. And I was getting ready to try a multiple brain injury, several parties, and wrongful death case in Arkansas. And we talked about the fact that what do those cases have in common? And are there principles that apply to each of those cases, even though they are very different cases? And even though I'm defending one and plaintiff on the other two. So what Dave asked me to do here today is to talk to you about how do you deconstruct a case? How do you prepare a case for trial, taking those principles that we've been talking to you about for years? How do you actually use those principles while you're getting ready for trial? And how do you use them in preparation? How do you use them in trial? Where do they really come into play? So let me begin with this. With me, every lawsuit begins with law. Before I get into any case of any type, I always start at the end and work backwards. I want to know what the court's charge looks like. I want to see the charge because I want to see the verdict form. I want to see the questions that the jury is going to be called upon to answer, because my job is to provide those answers. So I want to think about the jury question first, the verdict form. Then I want to go back and make sure that two things happen. One, my pleadings, and two, my body of evidence fit with the third thing, which is the court's charge in the verdict form. So I always want to know the law. I always want to know exactly what's my burden of proof in this particular case. And I want to know what the defenses are that I can anticipate, and I want to know what how can I deconstruct the defenses. Now, taking it from the top, the way we evaluate cases, or the way we prepare cases, is we'll start with the first element, it doesn't matter if it's negligence, breach of contract, whatever it is, but we work from a body of evidence. So we'll put I love those big sticky pads that, the big ones like this. You write on them, you stick them up on the wall. We've got a pretty good sized war room, and we end up with these things stuck up all the way around the wall. And here's how we do this. We start with, I'll take the element of negligence. Now, under negligence, we want to take all the evidence that we have, and here's how we evaluate it. You want to look at just on the issue of the negligence of this particular defendant. I want to know, number one, what is the documentary evidence that I have supporting this? Because that's the least changeable. Witnesses change on you. Documents don't usually. They sometimes do, but I want to know documents. Secondly, I want to know lay testimony. On the issue of this negligence of this defendant, what is every piece of lay testimony I have? Precisely who is the witness, and precisely what is this witness going to say about the negligence of this defendant? Then I want to know about expert testimony. Do I have expert testimony with respect to the negligence of this defendant? Who is it? What are they going to say? Is it a hired gun expert that the other side's going to hire one that's just going to offset them and the jury's going to ignore both of them? Or is this an expert that came up in the case naturally? Then I want to know about demonstrative evidence. What demonstrative evidence do I have? All the various types of demonstrative evidence. Photographs, any type of graphics, medical records, anything we can show a jury, visual evidence. And then I want to know the fifth thing is, what are all of the pretrial pleadings that we have that are useful now on the issue of negligence? Request for production, request for admissions, deposition testimony, anything we have that's already part of the record that we can use on this issue. Now, when we put those things up on the board, and we'll have all those up there, and that's just on the negligence of this defendant. Now, that is our body of evidence. That's the body of evidence as it stands right now on this defendant on this issue of negligence.